Hey Matrix, welcome back to the second video of legislation. So we are still on business environments. This is part 2. On the previous video I did Skills Development Act and SETAs, and on this second video we'll be doing Labor Relations Act and Employment Equity Act. So yeah, don't forget to like, comment and subscribe. Please share with your classmates, your cousins, your friends, anyone who is matric, those who are rewriting, whom you know that will make use of this information, and those who watched part 1 and are back again. Thank you very much for coming back, and for those who I know, I hope you stay and find a home here. Without wasting any more of your time, let's get right into it. So just a recap, this is what you have to know about each act, the purpose of each act, the impact and action regarded as non-compliance, and consequences or penalty for non-compliance. And what does it mean when you say you are compliant? That is also what you have to do. When you're compliant is when you abide by the laws governing that act. So every business is compelled to apply or comply with this act. So the Labor Relations Act of 1995 is the Act 66 of 1995. So you have to know that the purpose of the Labor Relations Act is to establish labor courts and labor appeal courts. So if somebody is being dismissed without any valid reasons, they can approach labor courts to have their disputes with the employer resolved. And it's also was started to promote fair labor practice between the employer and the employees, just to make sure that people are treated right, the way they are supposed to be treated, and nobody's taken advantage of. And it also provides for the right to lock out by employers as a reaction to lengthy strikes. Okay, and then they promote collective bargaining at the workplace, so they can be a discussion between the employer and the employee with regards to any grievances or problems that the employees may have. Now let's look at the impact. The advantages is a positive impact of Labor Relations Act on the business, and the disadvantage is the negative impact of Labor Relations Act on the business. So the advantages, it says, the advantages of Labor Relations Act on the business is that it protects the right of business in labor related issues. So the business is able to be protected when it has labor related issues. And then another one is that labor disputes are settled quicker and are less expensive. So them going to the CCMAs and all that helps disputes between the employer and the employee being resolved quicker than if they had to go to a court where the magistrates are dealing with so much, and it always had to be a case back. Also, the positive impact is that the Labor Relations Act promotes a healthy relationship between the employer and the employees, and then workplace forum can add value to business if it functions properly. So it also allow the formation of workplace forums. Workplace forums are just organizations within a business to help with different issues that affect employees. And then the negative impact of Labor Relations Act on businesses, this is the disadvantage. Costs of labor increase because of legal strikes. So that is the negative thing, because people are allowed to strike, but labor cost increases because of legal strikes. So when employees have went on strike, they have to be paid though they are not working. So employers may not get a court interdict to stop a strike. So the employer may not have the power to stop a strike. Even if they wanted to, there are some instances where they are unable to. Strike actions always result in loss of production for which employers may not claim. So yeah, it's bad for strikes, but the Labor Relations Act encourages it and allows it so that the rights of workers may also be heard. So it's the one that introduced strikes for people to engage in an industrial action. Yeah, reduces global competitiveness due to lower productivity. So if a country strikes a lot, it reduces global competitiveness because they are not able to produce as required. So let's look at actions regarded as non-compliance by the Labor Relations Act. So it means the Labor Relations Act, what can be, what would the business do in order for the Labor Relations Act to say their actions are non-compliant, which means they are not adhering to the rules of Labor Relations Act. Is preventing employees from joining trade unions is wrong. As an employer, you are not supposed to stop your employees from joining a trade union. It's their right. Another one is refusing establishment of workplace forum. They're very important. They should be established. It's required by the Labor Relations Act. The third one is forcing employees to give up trade union membership. That is wrong. Not allowing employees to take part in legal strike. They have a right to strike as long as they have valid reasons to do so. These are the penalties and consequences of non-compliant. So if you do the above things that I've just, the four above things that points that I just explained, this is what will happen to you as the employer. The employer may be forced to enter into a dispute resolution process. Business that fails to comply with the Act may risk financial costs, CCMA fees, they'll have to pay. Businesses will be fined if they fail to comply with the agreements reached during dispute resolution process. So any decision taken by the CCMA after a dispute resolution, the business is bound by law to comply. Ways in which businesses can comply with Labor Relations Act. How can you ensure compliance as a business, that you comply to Labor Relations Act? Is that businesses must allow employees to form trade unions. So it's just the opposite of non-compliance. So you have to do the opposite of non-compliance, and then you can get your marks. Employers should not breach, ignore any collective agreement. Allow or support the establishment of workplace forum. Employees should not be unfairly or illegally dismissed. And then rights under Labor Relations Act, we have the rights of employers and employees in terms of Labor Relations Act. So the right of the employer is to form a bargaining council for collective bargaining purposes, and is to dismiss employees who engage in unprotected strikes from employer organizations. Employer have a right to lock out employees who engage in illegal strike. So a lockout is when the employer is closing the gates and not allowing the employees who are striking to enter because they are vandalizing or breaking things in the business. So the right of employees is to refer unresolved workplace disputes to the CCMA. Again, is to refer unresolved CCMA disputes to the labor court on appeal, to embark on legal strike as a remedy for grievances. Now we are going to go to employment equity. The Labor Relations Act is just like that, guys. It has to deal with hiring, firing, and the admin of strikes, which in business studies we call industrial actions. So that is what labor relations is all about. Now let's move to Employment Equity Act 55 of 1998. So the purpose of Employment Equity Act is to promote equal opportunities in the workplace. So the first thing is to equal opportunities and fair treatment in the workplace. Remember, employment equity is equal opportunities. There are things that you should know about each one so that you can be able to remember their impact and so forth. Purpose of Employment Equity Act is to promote equal opportunities and fair treatment in the workplace. That's why it was started. Provide for employees to refer unresolved disputes to the CCMA. Protect employees from vandalization if they exercise the right given to them by the Employment Equity Act. To forbid any discrimination based on race, gender, or disability in the workplace. So we'll look at the impact of the Employment Equity Act on businesses. So the positive impact of Employment Equity Act on the business is that it encourages diversity in businesses by employing people from various racial backgrounds. So we should not discriminate. You can't discriminate against color and say you're only going to employ people based on their color, race, or gender. It does not allow that. Even disabled people should be given a chance to work. Provides employees with an equal opportunity to be promoted in a position. So anybody, if there is an internal recruitment, then anybody must be given a fair chance to compete for the job. It promotes equal opportunities and fair treatment in the workplace. So everybody must be treated with respect and equally. So no discrimination whatsoever should take place. Okay, so this is the advantage that it has on business, the positive impact it has on businesses. Now the negative impact that Employment Equity Act has on businesses is that expensive to train and employ someone who knows little about the act. Okay, increased administration burden as businesses must compile employment equity reports every 2 years. So there's a lot of work involved in it. Often positions go unfilled because there is no suitable employment equity candidate. So sometimes they have to employ a person of a certain race or gender just to balance things out, and recruiting might take a long time because it might be hard to find a person of those qualities or features or whatever that is missing, because they cannot find the right person to employ based on skills. So action regarded as non-compliance by the Employment Equity Act is denying people access to the workforce based on gender, race, or culture. You can't say you're not hiring people based on their gender, race, or culture. You can't say black people cannot work, white people cannot work, Indians and stuff like that, or women favor women above men or men above women. So, and it's not good. And another non-compliance is not employing a young woman because she will want to have a child in future. You do not do that. You take qualified people and you balance. Everything has to balance. You can't just employ male or female. Refusing to employ a person because he or she has a disability, it's regarded as non-compliance. As long as they're able to perform the job, then they have a right to be hired. So these are penalties, consequences for non-compliance to the Employment Equity Act. Fines may be imposed on businesses that fail to comply with its reporting obligation. Right? So fines may be imposed on businesses that fail to comply with these reporting obligations. Remember, there has to be a report that is compiled every 2 years by the business. So a fine will be imposed if that report has not been filed. The Department of Labor may block non-compliant companies from doing business with the government. So that's very important. You have to know it's one of the consequences. And the third one is businesses may be taken to the labor court for persecution if they do not take any regard for the Employment Equity Act. And then we have ways in which businesses can comply with the Employment Equity Act. Reasonable accommodation of people from ways in which the business can comply is to have reasonable accommodation of people from designated groups. So every group of people should be represented in the business. Implement an employment equity plan. So the employment equity plan should be implemented for a business to be compliant. Employees must be paid equal for work or equal value. No one should be paid, people on the same level doing the same job, nobody should be paid more than the other. They should be paid equal value. Business must guard against discriminatory appointment. So businesses should not appoint people on a discriminatory basis. So everybody must qualify and deserve to get that job. They also promote equal opportunities and fair treatment. So if a business promotes equal opportunities and fair treatment, then it's complying by the Employment Equity Act. So here is a question you can just do, and then I will show you. You can pause the video, try to answer these questions, and I will give you answers in a minute. Well, these are the answers. These are the answers, and I hope you got them all right. Thank you very much, guys, for watching. Don't forget to like, comment, and subscribe. On the next video, I will be dealing with Basic Conditions of Employment Act and the Broad-Based Economic Empowerment, also with the compensation for occupational injuries and diseases. So we'll be doing 3 acts on the next video. Thank you and God bless.